All right, I think we should start with the last session because we are a little bit behind time. And if people are still getting coffee, they're welcome to come in. I don't know if they're still using the overflow room, but there are seats here as well. So people are welcome to come in and sit down. So I'm introducing the fourth session. As James Reep said this morning, I'm not James Reep. He said the opposite. He was, never mind. You all get it. It's been a long day. But I am Patty Gerstenblith, and you have heard me earlier today. So I'm happy to be back to introduce this last panel and the two speakers. So this last panel is on the subject of cultural heritage, Indigenous and minority communities, and human rights. And we'll be hearing from two speakers. And as I said, I will introduce them briefly. You do have their full bios on your QR code or whatever in just a moment. But I want to say a few words about the intersection between cultural heritage and human rights, a connection that may not be quite as obvious to some of you. I mentioned this morning when I was speaking that originally Lemkin had proposed to include vandalism, in other words, the destruction of cultural heritage within the Genocide Convention. But this was rejected by several of the states, to make it an issue of whether they would ratify the convention if cultural destruction, cultural genocide, or vandalism had been included. Part of this was because of the reluctance of states to recognize the rights of their indigenous cultural groups located within their borders. And they preferred to focus on civil rights as the rights of individuals rather than human rights as a collective right. And this was, again, an issue to them of sovereignty and not wanting interference from the international community as to how they treated cultural minority groups, indigenous groups within their own borders. There developed a tension, if you will, of three levels or three perspectives through which cultural heritage could be viewed. One was universality, an appeal to cultural heritage as being the shared global or universal heritage of, and I'll quote in the words of the Hague Convention, of all mankind, or today we would say of all humankind. And I mentioned this morning that in the definition of cultural property, it's not entirely clear to whom does the cultural property to be protected, to whom does it have to carry this significance? And that is still an open and sometimes debated question. And it was, in fact, this appeal to universality which arguably contributed to the willingness of states to ratify the Hague Convention, because it was viewed as part of a shared global heritage that they should help to protect. But in reality, we know today it is not the international community, it is not the appeal even to universality, which provides the centers of power and authority for protecting cultural heritage. Rather, it lies with states. States decide what conventions they're going to ratify. In many cases, they will decide the parameters of that ratification by the enactment of domestic implementing legislation. And when they do that, that defines their obligations under the convention, not the convention itself, which I hope you can automatically see poses a problem. So states have the power and the authority, and the conventions also operate, for the most part, on a state-to-state basis. This means that if an action is to be taken under a convention, whether it's the restitution of a cultural object or interpreting military necessity or any of these other issues, this is done by states and in their relationship to other states. But today, a third element has been gaining traction, it's been gaining need for recognition, and that is at the community or the sub-state level. As I said, there was long a reluctance by states to recognize the rights of these sub-state entities. But this has been changing. There's been a series of international instruments, not binding conventions, but beginning with the Universal Declaration of Human Rights in 1948, the International Covenant on Economic, Social, and Cultural Rights from 1966, International Covenant on Civil and Political Rights, also 1966. Subsequently, several of the UNESCO conventions dealing with intangible cultural heritage have recognized some similar elements, and most recently, the United Nations Declaration on the Rights of Indigenous Peoples. Taken together, these instruments recognize the evolution of recognition of rights to access and to enjoy culture and cultural heritage, both as individuals and in community with others. It is particularly the idea of these as collective rights to be enjoyed in community as a group that has gained traction and presents the tension with state sovereignty, but at the same time is a growing factor that even states are willing to recognize. These rights include the right to freely participate in the cultural life of the community, to practice religion, protects the rights of members of ethnic, religious, and linguistic minorities in community with other members of their group to enjoy their culture, to profess and practice their own religion, and to use their own languages. The right to develop cultural heritage, including traditional knowledge and traditional expressions. These issues of recognition of the role of communities has gained particular importance with the last two predecessor special rapporteurs to the UN Human Rights Council in the field of cultural rights. Cultural rights was not, again, always viewed as encompassing what we think of as cultural heritage rights. But the preceding special rapporteur, Professor Karima Benoon, wrote, cultural heritage includes not only tangible heritage composed of sites, structures, and remains of archaeological, historical, religious, cultural, or aesthetic value, but also intangible heritage made up of traditions, customs, and practices, aesthetic and spiritual beliefs, vernacular or other languages, artistic expressions, and folklore. Both of these categories should be understood in broad and holistic terms. Both the special rapporteurs, Shahida Farid, the previous one, and Karima Benoon, recognized and labeled the intentional destruction of cultural heritage as a human rights violation. During Professor Benoon's mandate, the Human Rights Council unanimously adopted Resolution 3320, which brought the ability to access and enjoy cultural heritage within the right to take part in cultural life, condemned the intentional destruction of cultural heritage and the looting and trafficking of movable heritage, and called for recognition of the protection of cultural heritage as an important component of humanitarian assistance. And lastly, particularly Professor Benoon brought the problems and the threats, I should say, to cultural heritage defenders to the international community. We heard this morning from several defenders of cultural heritage who are very much on the front lines and who have been threatened and who are at great risk for their own survival. It is necessary for us to see their role, the role of the defenders and the role of cultural heritage as being integrated within our understanding of human rights law. So with that introduction to explain why we have our concluding session focusing on human rights, cultural heritage, and the context within armed conflict, I'm going to introduce the two speakers, well, one at a time. Just before I do that, I want once again to thank the Kernighan Center here at Columbia Law School under the leadership of Professor Jane Ginsburg, with, of course, the great assistance of Pippa Loengard, the executive director, and as well Samara Weiss. Also to thank the responsible art market, Birgit Kurtz, Nick O'Donnell, whom we heard from previously. I hope that you all appreciate this interdisciplinary approach to the problems of cultural heritage, interdisciplinary both within the field of law itself, as well as interdisciplinary across different academic and professional disciplines as well. So with that, it is a great pleasure for me to introduce our first afternoon speaker, Professor Federico Lenzerini, my colleague from the University of Siena. And as I said, he is a professor at the University of Siena Law School, and he is one of the faculty who teaches in the Siena program that is co-sponsored by Tulane Law School, DePaul University College of Law, and the University of Siena. And his title is, "It is not our war, but it is our heritage, the protection of Indigenous peoples' cultural heritage in the event of armed conflict." Thank you.
Okay, can you hear me?
Yes.
Well, very well. Okay, good afternoon to everybody. It's a real honor for me to participate in this symposium and This is the reason why I warmly thank, first of all, Professor Gestenblit, who had been thinking about me as a participant in the symposium, and also all the organizers for having allowed me to participate in the discussion. Well, my topic is relatively unexplored, but as Professor Gestenblit just said, in reality is becoming more and more topical day after day, because today within the international community, a new understanding of cultural heritage is developing and to a certain extent prevailing as well. An understanding which recognizes the significance of cultural heritage not only as regards what I'm used to call it as its substance, so its tangible aspect, but the intangible aspect as well, the spiritual part of cultural heritage, which in some occasions is even more important than the tangible component of heritage, especially for indigenous peoples. Now, when it comes to armed conflict, it is well known that indigenous peoples are among the human groups which are most prejudiced by the effects of an armed conflict. Normally, they are unable to defend themselves against armed violence. And so when they are involved, even, of course, without their will, in the context of an armed conflict, they're subject to trauma and irreparable harm. Their culture is destroyed, and the very social fabric of their existence is affected negatively. Generally, indigenous peoples are already marginalized within the society where they live, and so armed conflict worsens the situation. There are different kinds of violations to which they are subject. For instance, they are displaced from their territories. In some occasions, they have been victims of massacres carried out by the army or paramilitary groups during conflicts. And indigenous children are usually victims of forced recruitment much more than children belonging to other human groups. For instance, we have the example of the civil war in Colombia, and it was concluded after research on the impact of the civil war on indigenous peoples that an indigenous child was 674 times more likely to be forcibly recruited by an illegal armed group than a minor in any other part of the country. I could mention several other examples concerning the detrimental effects of armed conflicts towards indigenous peoples. For instance, we have the situation existing in some areas of the Philippines, especially in the Muslim Mindanao, in the context of which there have been huge damages, huge harmful effects for the indigenous peoples living in the land. Even in the context of the war in Ukraine, there is the situation of the Tartars in Crimea, which are affected by the conflict, if possible, even more than the generality of the society. Not to mention the situation of the first the Rohingya minority, and then more recently of the Karen people in Myanmar. In virtually all cases, the effects of armed conflicts against indigenous peoples translates into destruction or loss of indigenous peoples' cultural heritage. And this happens more than with regard to other human groups, because the concept of cultural heritage for indigenous peoples is particularly broad. So basically, almost all elements of their life, all elements surrounding their existence in the world are part of their cultural heritage. So When we think about the international norms aimed at protecting indigenous peoples, basically they protect all aspects of their life because their existence is based on an holistic conception, and cultural heritage is an essential part of this holistic conception in the sense that the cultural identity and integrity of indigenous communities is very much based on their cultural heritage. Once an indigenous leader said that heritage is everything that defines the distinct identities of indigenous communities as peoples. It is given to the current generations by the ancestors and is endowed to them by nature, and indigenous communities, the living members of a community, are simply custodians of cultural heritage in order for it to be transmitted to future generations. And it includes social, political, cultural, economic systems, institutions, worldviews, beliefs, ethics and moral values, customary laws, and so on. There was another indigenous leader, a very renowned one, coming from Australia, who once said that for indigenous peoples, being deprived of cultural heritage is like when you take a person and you decide to amputate the legs to this person, and then you ask this person to run the marathon. It's something which is impossible, like it is impossible to separate indigenous peoples from their heritage because they cannot live any longer. Their existence cannot exist any longer. And when there is an armed conflict, we know very well that what is destroyed is not only the tangible component of cultural heritage, but its spiritual component as well. We have, for instance, the example of what happened during the civil wars in Yugoslavia in the 1990s. And I refer especially to the systematic destruction of religious buildings in Bosnia and Herzegovina. That practice of systematic destruction was perpetrated not especially for affecting the tangible part of the buildings, but much more for destroying the spiritual connection existing between those buildings and the people for whom those buildings were particularly significant as an essential part of their life. And this is even more important for indigenous peoples, I repeat, in light of the holistic vision of life, in light of their very much spiritual-based life, based on spirituality. And as Professor Gestenblies just said, cultural heritage is strictly connected with human rights. There are many human rights which are affected when a community, and I am also referring to the collective aspect of this relation because for indigenous peoples it is particularly significant. So a number of human rights are affected when indigenous peoples are separated from their cultural heritage. Let us think about, for example, the right to participate in cultural life, which is provided for by a number of provisions included in human rights. For instance, Article 15 on the International Covenant on Economic, Social and Cultural Rights, and Article 27 of the Universal Declaration of Human Rights. According to the Committee on Economic, Social and Cultural Rights, this right implies that cultural groups have a right to be respected and a right that their cultural heritage is protected in all its forms, especially in times of war and in the event of natural disasters. So both persons at the individual level and communities at the collective level must be guaranteed the right to maintain, control, protect, and develop their cultural heritage, which must be preserved, enriched, and transmitted to future generations as a record of the human experience and aspirations of the community in order to allow the preservation of the cultural identity of a given cultural group, especially when it comes to indigenous peoples. Professor Gestenblit has already mentioned the right of minorities to enjoy their own culture, which in particular is provided for by Article 27 of the International Covenant on Civil and Political Rights. And even though this right refers to the members of minorities, thanks to an evolutive interpretation provided by the Human Rights Committee, which is the monitoring body established by the Covenant on Civil and Political Rights, this provision applies in particular to indigenous peoples, despite the fact that technically they cannot be defined as minorities under international law, and has acquired a collective perspective, even though the provision specifically refers to the members of the community, because, as you know, in the Western world, human rights are mainly conceived as individual prerogatives. And then there is the right to freedom of thought, conscience, and religion, also mentioned by Professor Gestenblit. The connection of cultural heritage with religion is very strict, because being allowed to preserve the relationship existing between a community, especially an indigenous community with its cultural heritage, is essential in order to allow the community to properly enjoy the right to religion, especially as regards the aspect of the right to manifest one's own religion. And as I have already said, this is on the more true as regards indigenous peoples, because they have a particularly spiritual understanding of life. Another right which is affected by the separation of communities from their cultural heritage is the right to property. And for indigenous peoples, this is particularly significant because thanks to the evolutive jurisprudence developed by human rights bodies, this right to property has been applied especially to the traditional possession of ancestral lands by indigenous communities. And this is a notable interpretation because, again, the right to property in existing human rights instruments is conceived as an individual right to be applied to the concept of property, to the concept of ownership, which is typical of the Western world. But in order to provide effectiveness of human rights and effective protection for the rights of indigenous peoples, human rights bodies, especially the Inter-American Court of Human Rights, have extended the scope of this provision in order to cover the collective possession of indigenous peoples of their ancestral land. And I'm talking about lands because the land for indigenous community is probably the most important element of their cultural heritage. And it is so significant, so decisive for the life of the community that in some cases, human rights bodies have found that separating indigenous peoples from their ancestral territories may amount to one of the most egregious violations of human rights. And I'm referring to inhuman treatment, because the psychological anguish suffered by the members of indigenous communities when they're separated from their traditional lands, and more generally, when they're deprived from the possibility of following and applying their traditions, is so deep that reaches the threshold of inhuman treatment. that is a violation of jus cogens, so one of the most serious violations of human rights. Now, there are some provisions in the instruments already mentioned by Professor Gestenblit concerning both the right of indigenous peoples not to be affected by armed conflict and the right to indigenous peoples to preserve the connection they have with their cultural heritage. I use this expression to emphasize that when it comes to the relationship existing between indigenous peoples and their cultural heritage, it is not so much a material relation, again, but much more a relation of spiritual character. So it is not a matter of material possession, but a matter of preserving the link existing with cultural heritage as an element which determines and totally influences the life of the community and its members. In particular, probably the most developed provision in this respect is Article 31 of the United Nations Declaration of the Rights of Indigenous Peoples, which establishes that indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions. And there is a long list of elements which are part of cultural heritage. Now, the problem is, as regards the main subject of this symposium, the Hague Convention, for sure, when the Hague Convention was negotiated, drafted, and concluded, nobody probably had in mind cultural heritage of indigenous peoples. As I have already said, the main elements of cultural heritage are not included within the definition provided by the Hague Convention, especially the definition, as well known, is included in Article 1. And Article 1 uses the expression cultural property. And you know that, especially under the contemporary perspective, there is a notable difference between the expression cultural property and cultural heritage, because property refers more exactly to the tangible component, while heritage is more encompassing, is a broader concept because it encompasses all the elements, all the components of cultural heritage. But there is that very interesting sentence included in the preamble of the convention, which is probably one of the most quoted sentences taken from cultural heritage treaties, which is the second sentence of the preamble, according to which the negotiators were convinced that damage to cultural property belonging to any people whatsoever means damage to cultural heritage of all mankind, since each people makes its contribution to the culture of the world. Now, as regards the definition included in Article 1, as you know very well, it refers to movable or immovable property of great importance to the cultural heritage of every people, such as, and then there is the list of the elements of cultural heritage which are protected. So apparently, it is quite problematic to consider this convention as applicable to the cultural heritage of indigenous peoples, or at least to part of the cultural heritage of indigenous peoples, because of course there is also a tangible component in this cultural heritage. If we think about, for instance, ceremonial objects, works of art, human remains, they are anyway particularly important for indigenous communities, and they are clearly subsumed within the definition provided by Article 1 of the Hague Convention, even though of course, for indigenous peoples, what is particularly important of these elements of cultural heritage, again, is not their tangible component, but rather the intangible aspect. So if we think, for instance, ceremonial objects are important for indigenous peoples, not much because they may be works of art or anyway beautiful pieces of the human genius, but they're important in particular because they play a decisive role in the realization of the ceremonies. So again, it is the spiritual aspect which prevails. Of course, when we think in particular about traditional lands, natural resources, ceremonies of indigenous peoples, which may well be destroyed by armed conflict, how is it possible to consider them as included within the scope of the Hague Convention? Of course, this is possible, in my modest opinion, if we accept the idea of an evolutive interpretation, again, of the provisions of the Convention. First of all, both the sentence in the preamble that I have quoted and Article 1 refer to the word people. Probably when the Convention was adopted in the 1950s, the concept of people only referred to national peoples as a whole. But today, there has been an evolution of this concept, and we can safely assume that this concept of people may include also communities within the state, even minority communities, and in particular, indigenous peoples. So under this point of view, we can reasonably assert that the term people used in the Convention covers indigenous peoples as well. Then there is the problem with the term property. But if we refer again to the sentence of the preamble, this sentence makes it clear that cultural property is the cultural heritage of peoples. So, especially in light of this provision, you know very well that when it comes to international treaties, it is not possible to use the preamble as a source of obligations. But at the same time, the preamble is an instrument for interpreting the provisions of the treaty. So to understand what is the purpose and what is the scope of the treaty. So it is quite, I don't want to say easy, but it is possible to interpret this term property in an evolutionary manner in order to include also elements of cultural heritage which are not listed in the definition in Article 1. And then in Article 1, you have this expression such as indicates that the list included in the provision is not closed. So it is just a list which is included as a matter of example. And this paves the way for inclusion of other elements of cultural heritage, in particular, indigenous peoples' traditional lands and living resources, and all elements of cultural heritage which probably were not properly considered in the 1950s when the convention was adopted. So, I'm going to conclude. What we need is just an evolutive interpretation of the provisions of the convention. It is an interpretation technique which consists of adapting legal provisions drafted in the past to the current needs of the international community. They allow to update the contents and the scope of treaties without modifying their text and make them respondent to the current needs of states and the international community as a whole. So there is the need to interpret the Hague Convention in a way that is consistent with the basic values pushed today by the international community. Holistic understanding of cultural heritage as including, like Professor Gestenblitz said, not only tangible but also intangible heritage. And personally, I prefer to refer to cultural heritage as encompassing both aspects, because it is not even very correct to distinguish between tangible and intangible, of course, in my opinion, because most elements of cultural heritage, they have together both elements, the material and the immaterial. And this kind of interpretation could be reinforced by the domestic legislation of states implementing the convention, and also, in particular, the special agreements which are contemplated by Article 24 of the Hague Convention. With those special agreements, states could define the interpretation to be provided by the convention in order to include the cultural heritage of indigenous peoples as well. And this would allow to safely encompass this cultural heritage within the scope of application of the convention. Otherwise, indigenous peoples will remain marginalized, and the application of the convention would not respond to what are the current needs of the international community today in terms of protection of cultural heritage. In general, and this is my last consideration, in general, it is always possible to establish special agreements between two or more states parties to an international convention. And these special agreements play the role of lex specialis, of special law, in comparison with the general provisions of the convention. So this could be done, for instance, also with regard to the second protocol to the Hague Convention, which, as you know very well, provides a better protection of cultural heritage, even in the event of conflicts of non-international character. And in most cases, indigenous peoples are exactly affected by this kind of conflicts. So this evolutive interpretation and this commitment by states to give a meaning to the Hague Convention in order to encompass the cultural heritage of indigenous peoples could really allow to provide an effective protection for this cultural heritage. Thank you very much.
Thank you very much. That was very interesting and thought-provoking. I especially appreciate, I know it's very late in Italy where you are, so I am particularly appreciative of your willingness to speak at this time. It does represent some of what we discussed within the Blue Shield movement, which is basically, is intangible heritage something we should be working to protect along with the tangible? So this is extremely timely. I've even had a colleague say, there is no such thing as tangible cultural heritage. It's all intangible. And the function of the physical, of the tangible, is only to allow us to enjoy, appreciate, and understand the intangible. So that interrelationship between tangible and intangible is something that will continue to evolve and that we need to continue to respond to. So again, thank you for that. If you can stay, there might be some questions later on. As again, I know it's late for you, but if you can stay, that would be great.
No, I would be glad to stay. Thank you.
Thank you very much. Our last speaker for the day, second speaker for this panel, is Dr. Brian I. Daniels. I already mentioned that he is a member of the Blue Shield Board, the U.S. Blue Shield Board, and he is the Director of Research and Programs at the Penn Cultural Heritage Center at the University of Pennsylvania. And his topic is the issue of recognition when returning cultural objects to Indigenous and minority communities.
I'm hoping this works. Yes. All right, first, I would like to thank the Kernighan Center and Columbia Law School for their incredible hospitality throughout the day, and our conference organizers for putting together a series of very thought-provoking panels, and also for inviting me for, in some ways, having the last word in this particular conversation. I also want to thank Patty Gerstenbliss specifically, who asked me to offer thoughts on this topic. And I have to say that comes with a certain degree of trepidation, because I am speaking now at 4 p.m. on a Friday afternoon in front of a group of attorneys, and I'm going to be offering some speculative thoughts about really what it means to undertake the work of returning cultural objects, but the kinds of barriers that occur to the pragmatics of actually engaging in that work. And so I want to begin with a problem that we have noted throughout the day, and that is there is widespread conflict theft of cultural objects. It's something that has come up in every panel. It is something that it is unfortunate to note that whether we consider cultural objects a form of war booty, a position that has since been rejected in international law, or we simply think of it as a dynamic of conflict, we have museum theft, such as at the Kherson Regional Art Museum in Ukraine, that both Patty and Roxolana mentioned in their talks. We have archaeological site looting in places like Dura Europos in Syria. Here, the pink inside the ancient city walls and the yellow on the outside. But we have a phenomena here that is widespread. And despite our best set of law, but despite our best set of regulation, despite our best set of sanctions or whatever compliance mechanisms we may develop to try and prevent those objects from entering either the collections of cultural institutions or in private collections or to cross international borders, this movement has happened, and unfortunately this movement continues to happen, although we try our best efforts to arrest that kind of ultimate consequence. And so we are faced with the conundrum that certain conflict-looted objects are meant to be returned. And we have an international paradigm that has evolved around this topic. And I think, and here I really am, and for the remainder of this talk, in dialogue with this theme from Patty's new book on cultural objects and reparative justice, about what this paradigm means and how to actually engage with it. And in this work, I mean, she argues that this functionally what you see on your screen is the paradigm of objects that definitely need to be returned. Human remains that have been acquired by institutions without informed consent, funerary objects, those objects associated with a burial, inalienable cultural objects, which we may think of wrongfully alienated objects like objects from museums or individually possessed objects, such that were looted during the Holocaust, for example. Objects from integral monuments, where the objects that compose that monument. Here we think of objects like the Parthenon marbles, for instance, and other representative collections, where we deal with colonized countries who have had their cultural objects exported such that there are no objects of that type left remaining in their countries of origin. Now, the first issue I see with realizing this paradigm of repatriation is the political problem, the decision to repatriate. And I think that one of the themes throughout this particular conference and the discussions here is that there is a willingness to return objects broadly in our subset of the field when objects have been wrongfully taken and they can be shown to have been wrongfully taken. But I don't think that position is taken willingly and easily broadly. And so the decision to repatriate Native American material in the United States required a federal law, the Native American Graves Protection and Repatriations Act. even inside museum institutions with their own institutional politics, there is still a political decision to repatriate. At my own institution, at the Penn Museum, the ultimate decision to repatriate is not made at the level of the Penn Museum. It's made at the level of the University of Pennsylvania Board of Trustees. And so every individual object that might be returned from the museum, regardless of whether it's for NAGPRA compliance or if it is an international repatriation, ultimately must be done at the level of those internal institutional politics. The second problem I see, and this is one that Patty alluded to a moment ago, is that we have three different levels of claims that really do reside here. One toward the universal, and there's certain kinds of universal rights, which I do see coming to nest in the Universal Declaration of Human Rights. But also at the second level, more crucially, in sovereign rights and treaty rights and state-to-state rights. And so this really is the location in which the action has come to reside. But increasingly, we have local communities and local rights bearers and stakeholders that have claims to cultural heritage, like Federico just so eloquently argued, the inalienability of land, language, and other kinds of culture to local indigenous peoples. Now, we know that we've tried to resolve some of these issues before. Certainly when dealing with Holocaust returns, we have had this tension between the rights of individual families and heirs deprived of their artistic property, and oftentimes their lives. But the very fact that we continue to have arguments about this, and the very fact that this remains unresolved, and even the good work that is done, like at Sotheby's, around organizational compliance around Holocaust-specific art, right, points to the fact that there exists this tension, that the Holocaust returns were perhaps done and handled imperfectly in the immediate years following the war. And this brings me to essentially my primary gambit this afternoon, is that we are really talking through a distinction between property-based approaches and people-based approaches when dealing with cultural heritage. And in part, I think this stems from the desire, and in many ways the need, to understand how to read human rights into the cultural heritage field more broadly. Something that, as Patty mentioned, was the effort of the past two special rapporteurs for cultural rights. But I think that something that really has been a transformative change in the field that NAGPRA, at least in the United States, did bring about. The kind of consultative engagement with Indigenous peoples about the kinds of cultural heritage they wanted to possess and see protected. And so I would argue right now that we are in the midst of a field-wide transition on this topic from a property-based approach to a people-based approach. And what we are fundamentally struggling with is how to accomplish this transition and what kinds of both legal mechanisms, compliance mechanisms, ethical mechanisms that we more broadly need as a field to make this transformation. And again, this is a framing that I adopt actually from Patty in a 2016 article of hers about the distinction of cultural heritage crimes, whether these are property crimes or whether these are crimes against people. And those of my students who are here or who are watching will know that I teach this article for exactly this purpose, because I think it encapsulated exactly the kind of problematic that we're trying to work through. So what does it mean fundamentally to have an outcome that is focused on people rather than an outcome focused on property? And in many ways, I'm trying to follow my own example here with the fact that I put the photograph of the portrait of Adele Bloch-Bauer next to Maria Altman here, as opposed in the previous slide of just the portrait of Adele Bloch-Bauer. to emphasize that there was a violation of the Altman's family's rights when it came to this particular work of art. But I want to argue that there's a more central feature to this than perhaps shifting what's in a photograph. And that is perhaps what we're really talking about here fundamentally is the mechanism for recognizing rights bearers. I think that this has been easily and perhaps too easily defined when it comes to sovereign rights. And perhaps that's why we get stuck at that second level. But instead, what I want to do is I want to explore for a moment exactly how we think through the issue of recognition when it comes to Indigenous peoples and the question of recognition when it comes to minority rights. So first, let me turn to the question of recognition of Indigenous peoples. And in some ways, the answer to this seems in many ways self-evident because the United Nations Declaration on the Rights of Indigenous Peoples clearly sets out in Article 3 that Indigenous peoples have the right to self-determination, and that under Article 4, Indigenous peoples in exercising their right to self-determination have certain rights to autonomy, self-government, that leads into other kinds of questions about maintaining and strengthening their politics, their economies, and their economic, social, and cultural institutions. But, and there is a big but here, the point I wanted to draw here is that the UN Declaration of Rights of Indigenous Peoples is very unevenly implemented, and it still must be implemented by state parties to recognize Indigenous rights, Indigenous peoples recognizing their rights to self-determination. So this is still a state-by-state kind of framework. And in order to receive objects under NAGPRA in the United States, we have a process that's clearly laid out under the law, Section 3A. And there's an order in which a repatriation occurs. For human remains, it's immediately to the lineal descendants, and then on to the tribe or under a tribe who can demonstrate a cultural affiliation. For cultural objects, it is to the recognized tribe. Now, this creates something of a problem. So it is a fun fact that we are here on Manhattan, and the two closest Native American tribes, one is federally recognized and one is not federally recognized. But the tribe that is not federally recognized has a reservation that predates the Declaration of Independence, established with the British Crown. And so it is not obvious that Indian tribes are recognized for the purpose of NAGPRA and the purpose of receiving cultural objects. Across the United States, in fact, there are 574 recognized tribes that are so recognized by treaty, executive order, act of Congress, court order, or a particularly obscure piece of federal code known as the Federal Acknowledgement Process. And of those 574 federally recognized tribes, only 18 have been recognized under the Federal Acknowledgement Process. This is a particularly arduous process. It involves showing that an Indian tribe has survived efforts to erase its existence, that it can be identified by scholars or in other federal documents, that the community has maintained integrity despite all obstacles, that it has maintained political influence, that it has a unique membership, and it can show genealogically descent. And finally, that it has not been terminated by an act of Congress. The average length of time it takes to fill out these criteria is 28 years. And the General Accounting Office estimates the cost at $2.1 million, which most federally unrecognized tribes simply don't have. And this is an area I do a lot of work in. And one of the things that I've experienced is now generations of Native people dying trying to identify their recognition. And that hurts. And I know how much it hurts these Native communities because they want to be recognized to participate in NAGPRA, right? Understand that that's the threshold issue. If you don't go through this process, even though we have a process of repatriation, this is not for your tribe. So what can heritage professionals do in this space? Well, one of the things that I think is that, honestly, this community, if it is really concerned about repatriation and repatriation to Indigenous people, spend some time thinking about what tribal recognition is. I hear a lot of self-congratulation, especially in media, about meeting the bare threshold of NAGPRA requirements of repatriation these days, without any consideration of the literally hundreds of tribes in this country that cannot participate in the NAGPRA process because of this threshold. And I also think that the heritage community, because when you think about people interested in this field, tend to cross interesting kinds of domains of knowledge. It requires knowledge about culture and heritage and law and history and how to analyze that kind of information. That is exactly what is necessary in the federal recognition process. I want to turn to minority and other community rights now. That other leg, and as Federico so aptly said, these are different categories, right? We cannot treat minority and community rights as Indigenous rights. And I think that one of the big problems here is that we are now dealing with the situation, perhaps more acutely, that the state cannot be a guarantor of cultural rights. And so how do we deal with the problem of return when we have serious questions about state action and state intent? And the first thing that I will flag is there needs to be more knowledge and awareness of this. And I think that we can really point to and advocate for language around the Foreign Assistance Act to try and encourage in the regular human rights reports of the Department of State, the annual country reports, particularly egregious instances of cultural property destruction, theft that is tolerated by that government, especially when it's directed toward ethnic and religious minorities and Indigenous peoples. This is one way, I think, of really embedding cultural rights into the overall suite of US policy around human rights. We've already mentioned, when we think about grounds for how we try and activate among minorities and communities their rights, we have an appeal to the right to realization of cultural rights in Article 22 of the Universal Declaration of Human Rights. We have the right to freely participate in the cultural life of a community under Article 27. But I'm not sure that either one of these per se is enough to get us to the threshold of how we might advance an argument about recognizing minority rights holders or community rights holders. And here I want to instead turn to Article 20. The idea that everyone has the right to the freedom of peaceful association, and also the right that no one may be compelled to be a part of an association. So think perhaps here about the right to not be compelled to be a part of ISIS, for instance. But perhaps we can think about and explore, and this is again where I said this was a speculative discussion, what kind of recognition might we give to organizations freely associating around the preservation of cultural rights, and perhaps even the possession of cultural objects? And here I would point to the fact that there are organizations that populate this field. The U.S. Committee of the Blue Shield, ICOM. So we have professional organizations and advocacy organizations. And I think that there's a role here for friends organizations of cultural institutions, which right now really only exist at the largest global cultural institutions. But I would point to also religious organizations and perhaps even provisionally certain kinds of charitable trusts that hold cultural heritage for public benefit. And here I think that perhaps one of the paradigmatic examples may have been the Afghanistan Museum in Exile in Switzerland that was established after 1994, specifically to hold ethnographic cultural material from the National Museum of Afghanistan and in other parts of the country that it was at risk for destruction, but in which was organized specifically to still invest property rights in the Afghan state for whatever day that repatriation might be able to occur. And perhaps after listening to Fahim Rahimi earlier, it's time to also keep thinking about what kind of future Afghanistan Museum in Exile might now be needed for the tragedies that are unfolding there. I think here too, that there is a strong need for conversation about what these rights-bearing organizations may look like. And so my answer here is the need for dialogue and the need for conversation and the need to try and understand what these organizations might be and how they might thrive under specific kinds of state law and state regimes, both domestically and internationally, that then could be recognized as their own, as certain holders of an unbundled kind of cultural rights. So here I think about the work as the work is ongoing and the work is evolving and the work as deeply provisional, but one that I think is more urgent than perhaps we've imagined. So I want to offer a few concluding thoughts about what heritage professionals can do to help with the problem of recognition. The one thing I'm sure of is that we need creative alternatives for scenarios where cultural rights are not guaranteed by a state party. And we need, as a field and as a broader professional community, to think through what that might look like. This is going to be, I think, the next problem of this generation, especially as in many ways the politics of repatriation have come to be recognized in that paradigm of restitution. I think that very much so, as I've said, heritage professionals can advocate for recognition of rights holders, as we can for Indigenous peoples, and we can explore fundamentally what that looks like for other minority communities. And I think that ultimately it's going to be up to this field, if this field is deeply serious about the transition from caring about property to caring about people, to think about developing the civil society organizations that ultimately can serve as rights holders at that sub-national level. Thank you very much.
Thank you very much. A lot to think about there. A lot of way forward for future scholars, future heritage professionals to try to figure out how to resolve some of these questions. We do have a few minutes left if there are any questions or comments. First from inside the room. I know it's Friday afternoon and people are packing up their things, but if there are any comments or questions, or Samara, is there anything coming in from outside?
We have a three-part question from a representative of a museum in Egypt. She says, what is the role of the Convention on the Protection of Property from Armed Conflict and the Unidroit Convention in return of looted and stolen antiquities and preventing the sale of antiquities at public auction? How can antiquities be protected from trafficking? And what are the ethics of museums when selling antiquities at a public auction, especially what happened about 2,000 Egyptian pieces were stolen from the British Museum and sold at public auction, she says.
Maybe I'll give that to the market panel from before.
Yes, sorry.
There's a lot there. I don't think we can answer that. I don't know if you want me to take a first stab at it. I'll just briefly say it, and this is partly, I was thinking of making this comment in the previous panel. The Hague Convention actually says nothing about the market. It prohibits the taking by the military or responsibility on the military to prevent others from taking cultural objects during armed conflict. But the main convention does not speak to what happens to those objects after they have been stolen. You're not supposed to steal them. Doesn't tell you what happens after if they are stolen. The first protocol imposes an obligation to return objects taken that one state an occupying power has an obligation to prevent things from being removed from occupied territory. And if something shows up in your country, even though you're not the occupying power, you have an obligation to return it. But that's still pretty limited. Only a few countries, as far as I'm aware, market countries, the UK, Germany, the Netherlands have adopted specific implementing legislation for that to prevent the import of cultural materials taken from occupied territory. And although I'm already in the weeds without getting too much further into them, particularly the UK legislation implementing that is extremely narrow and unsatisfactory, in my opinion, in its definition of what constitutes occupied territory. So in that regard, I think the Hague Convention is entirely inadequate. And then on the other hand, you've got the trafficking conventions like the 1970 convention, which again is largely defined by how particular countries implement them. I'm trying to remember everything that was in the question there. There are no specific obligations on auction houses, I will say. Auction houses are not any different. And in fact, auction houses usually don't own the property that they're selling. So really the obligation from a legal perspective is on the consignor. Dealers, we presume, although again, it's not accurate today any longer, that they own the property that they're selling. So, but there's no legal differences for the most part, with some minor exceptions that apply to auction houses as opposed to dealers or any other seller. One last comment. The 1995 UNIDROIT Convention doesn't address armed conflict specifically, and it is part of what's called private international law. The Hague Convention, the 1970 Convention are public international law. They operate, as we've said, on a state-to-state basis. The UNIDROIT Convention's private international law simply gives countries and also private individuals the opportunity to recover stolen or illegally exported cultural property, but nothing specific there about armed conflict. So I'm not sure I've answered everything in the question. I don't know if either Federico or Brian want to add anything to that.
That's about all right.
That's quite right. I don't know if we've lost Professor Lenzerini, if he's still there, if he has any comment. I will ask.
Can you,
go
I'm
ahead.
still here, yes. But I don't think that I have anything to add what you have just said about these issues.
Okay, thank you. I know there's one question here, yeah.
Yeah, with regard to the recognition of, I think, not just Indigenous communities, but sub-state entities, however you want to define those. I recognize in the US there are a lot of problems with federal recognition, but one of them is one of the not so much problems, but that a lot of Indigenous nations refer to is that by having a system of recognition, it ensures that there is some credibility to the entity that is requesting repatriation or return. So I'm curious if you have suggestions for how to evaluate, absent some kind of formal recognition system, the authority of a particular group to claim some kind of work, and how you might mitigate potentially competing claims amongst communities.
So what I would say is I'm going to sort of take the question with regard to Indigenous peoples on the one hand, and then with minoritized or other kinds of local communities on the other. I think with Indigenous peoples, and this is, I think, not just true in a U.S. context, but Mexico has a system of recognition through its ejido system. Argentina has a system of recognition of Indigenous peoples. So it's not as if state actors are not finding ways to evaluate credibility. Whether or not we fully agree or endorse a particular state's theory about Indigenous recognition, I think, is a topic for debate. It's also a topic of, I think, intense advocacy. So I think in some ways that's actually a bracketable issue for Indigenous peoples. I think that the alternative in some ways is actually dealing with other kinds of competing minoritized community rights. And that one, I think, is actually a much more difficult question to answer, in part because we haven't envisioned what kinds of rights-bearing entities would exist to be able to make the claim in the first place in order to understand what competition between their claims might look like or what kind of adjudication may be necessary. The short of it is that it may be in some ways about the public marketplace of ideas, in fact, about the ability of these different community groups to be able to actually advance a claim to a particular kind of object. I'm thinking a little bit about Kristen Carpenter's recent work on the subject here as maybe a partially provisional answer in terms of being able to gain broad kind of public support for their particular rights, for their particular cultural rights.
Thank you. I think we can do one last question if there is, but if not, we actually are 10 minutes over time. So again, I want to thank all the participants and particularly the attendees. And I guess, Pippa, you want to close down?
Got a list of
Okay.
those things, and one of them is you. So no, I want to thank, as Patty just said, everyone who's been with us here and online. Our sponsors, the Responsible Art Market, Thompson Hine, Goldman Sachs, the Art Risk Group, Sullivan and Worcester, the U.S. Committee on the Blue Shield. We couldn't have done this without our organizers, Patty leading the charge, Patty Gerstenbluth, Jane Levine, Nick O'Donnell, Birgit Kurtz, Kathy Kaplan, Kate McGrail, the CLS students who have helped us out all day. So thank you. And two things. One is don't forget to sign out because you don't get CLE if you don't sign out, and you should have gotten an evaluation, which we do value. And lastly, I know that her name has been said frequently, but I just want to thank Samara Weiss, who, unlike the rest of us, got sort of dragged into this involuntarily and has been a trooper. So thank you, Samara. Appreciate it. Please follow everyone online. We all have online presences, and we look forward to hearing from you. Take care.